Good afternoon, everybody. Thank you so much for joining us for our fireside chat as we discuss today demystifying probate. What is it? Is it the big scary monster that we've all been taught that it is? Do you want to avoid it? How do you avoid it if you do? All those questions we're going to answer today. I'm Jan Kraft. I'm the author of Leading Lightly, Getting Your Affairs in Order So All You Leave Behind Is Love. I'm joined, of course, today by my friend, my mentor, and the owner of ELG Estate Planning, Lynn St. Louis. So Lynn is going to be talking to me about probate today. Lynn, hi.
Hi, Jan. Thank you so much for that introduction. We want everybody to participate to the extent we can. So put your questions in the chat. Stay with us to the end, and then we'll be talking about some really useful, helpful information that we'll be able to share with you. So, Jan, I'm looking forward to your questions. So let's get started.
Then you know me, I always have questions. So the first question is, it's just a very basic. I like to start out with the basics. What is probate?
Well, that would take the whole chat, but let me make it, or the whole time today, but let me make it as simplified as I can.
Okay.
Probate is the legal process to administer the estate of someone who has died. That's what probate is. Where it gets more confusing is when we talk about the details of probate, the what, where, when, why, and how. So I'm happy to go into that, but I might be jumping a little bit too much. So Jan, I'll
ask you. I'll ask you those things. So the first question that I have, though, you said is the legal proceedings that happen when someone dies. So we are all going to die at one point or another. So does probate always happen?
Probate does not always happen. So let me give you a few more details about probate, and then we can get into why it doesn't always have to be necessary. Okay. So think of probate as this process. We all know what a will is. That's where we put our last wishes. Who's in our life, who's our family, where do we want our stuff, our money to go? That's what your will says. Now, how does this will, how is it implemented? A will has no effect until somebody has died. When they die, that will needs to be filed in the county of their residence, typically in the state where they lived. And who does that? It is the personal representative or the executor. And when I say they file it with the court then issues an order that says, yes, this is a valid will. You, personal representative, are authorized to implement the will, and then the next steps happen.
So you're talking about when someone has a will, then the court validates the will. What if somebody doesn't have a will?
So if someone does not have a will, there still may be a probate. A lot of times people think that probate is just about a will. Well, let's say you've done no estate planning, and if you've done no estate planning, there's a very, very good likelihood there will be a probate if you have any assets. Where's your house going to go? Where are your bank accounts going to go? Where are all these other assets? Where's all this stuff going to go? If you haven't done a will, there likely will be a probate, and then the state will decide under the laws of intestacy, is what it's called, where your assets go.
So for me, that's the scary part, because if you don't, as I understand it, if you don't decide yourself, then the court decides for you, right? And so where I have a problem with this myself is that if they're, all of the families that I've been privileged to know as a minister, I've seen it time and again, there's always some dysfunctional things going on. There's some family members you do want to inherit and some family members you don't want to inherit, or maybe you want an organization to get your money and not the heirs or whatever. So if I don't say that, then the court's going to decide that, and the court's not going to know, because a judge is going to be assigned that you don't know, right? He's not going to know me. He's not going to know my family. He's not going to know the family dynamics. And if I understand it correctly, the court goes by state law, right, in determining who gets your money and where your assets go. Is that right?
That's exactly right. So shall I give you an example of what the laws of intestacy would say here in Washington?
Oh, yeah, please.
Okay. let's say you're a single person, and let's say you have 3 children. Let's say you're estranged from one of them, but you didn't take the time to do a will to say, I don't want that estranged child to inherit from me. Because you did not do that work, then what's going to happen? You don't have a will, is all 3 children will inherit equally, because the laws of intestacy are what the court thinks that most people would want. And if you want something different, then you have to be clear about what it is that you want is different.
So let's say that whether I have a will or whether I don't, I die and my estate goes to probate court. So my first question, 2 questions really come to mind. One is, what is I would say I don't have an estate because I don't have a lot of money, I don't have a lot of assets, etc. So, and you said that sometimes I could go to probate court, sometimes I wouldn't go to probate court. What's the difference? What determines whether I go to probate court or whether I don't go to probate court?
So what makes the difference is, have you done any estate planning? If you have done no estate planning, you say, I'll leave it up to somebody else, then frankly, there will be a probate and the state will decide where everything goes, no matter how small it is. So what makes the difference is your estate plan. And what I mean by that is your estate plan set up to benefit from probate? And we can talk about how that works. Or is your estate plan set up to avoid probate because you didn't want a probate because there was no benefit? So all of this is premised on you doing planning. If you want to make sure that things are as easy as they can possibly be for your loved ones, the folks you leave behind, and your assets go where you want them to go as simply as possible, everything depends upon you doing some upfront planning. We call that your estate plan.
Sure. So I get that it's up to me. It's up to me. So, and that if I plan correctly, maybe I don't have to go through probate. So here's the question that I have is, I was taught, and I don't know why, growing up, you get taught these really strange myths and you just accept it as truth. And then you don't ever question it. And one of the myths that I grew up with was that you never wanted to go into probate. It was kind of given to me like probate was this really big, scary monster. It cost a lot of money. It was very technical, and you had to do, it's like having to go through probate was like having a venereal disease. It's something you never wanted to have happen to you, right? So, and I suspect that that's not exactly true. I would suspect, just on what I know about it, that it can sometimes be true, but not always true. So my question to you, Lynn, is probate the big scary monster that we've always been told it is, or is there a milder version of it or a different version of it?
It can be all of those things, Jan. So when you hear about probate as being terrible, avoid it at all costs, it's expensive, it allows people to fight and argue and waste money and all of that comes back down to, well, they didn't have an estate plan in place. If they did, there would not be such difficulties with probate. I do want to take some time today when we talk about how do you avoid probate, why might you not want to avoid probate, what benefits could there be from probate. So, as a general rule, I think most everybody would say, probate, I want to avoid it. And it's really funny. Some people think that if they've signed a will, that means they've avoided probate.
Yeah, I always thought that.
Yeah, a will is just one part of your estate plan. And if you want to avoid probate, then you can still have a will, or perhaps you have a revocable living trust, or perhaps your attorney helped describe for you what would be best for your estate to avoid probate, even without a revocable living trust. Revocable living trusts are supposed to avoid probate. They don't always do so, but that's a different topic. But there are very good ways to avoid probate, and that is more important when people have more of a simple estate, a smaller estate, because if there's not a whole lot to deal with and we're not worried about taxes, then maybe we do want to avoid a probate, but that has to be done through estate planning, not at the last minute, because if it's the last minute, there will be a probate.
Right. And I think that last minute is one of the things that I want to get across to everyone who's listening to this webinar, is that if you wait until the last minute for anything, and especially as it relates to estate planning, whether legal or non-legal aspects, which is what I deal with in Leaving Lightly, if you wait until the last minute, you're always going to be running into problems. Especially if you don't decide yourself and you're having someone else decide for you. It really causes massive problems. So getting clear yourself now and taking those actions are really the best things that you can do for you, for your estate, and for the people that you leave behind, obviously. So Lynn, you've been talking about, just now you've been talking about reasons to avoid probate, and then you also said that there's reasons not to avoid probate. So can you explain the difference there between when you would want to avoid probate and when you wouldn't?
Okay, so let's use some examples. Avoiding probate. Let's say you are a single person and you have 3 kids and you have a house and you have a bank account, investment account, maybe life insurance, maybe retirement accounts. And in whatever your situation is, you know that the people who are going to inherit from you, let's say your 3 kids, and it could be just 2 of the 3. But let's say that you are setting up your plan to avoid probate. How would an estate planning lawyer counsel you to do that? We would say, all right, do your 3 kids get along really good? Well, yes, they do. Well, then we can do a transfer on death deed on your house. And this is something that's relatively new. It used to be that you could not transfer a house through a deed on your death. Well, now you can. And when I say do they all get along, because if you're transferring your house to your 3 kids on your death via this deed, they're all 3 going to be owners. And if they're going to be fighting and disagreeing, that's probably not the best option. But if they're all going to agree, sure, we're going to sell it and take the proceeds, and that's not going to be a problem, then you will avoid probate by doing a transfer on death deed. What we're looking at is what direction can we give assets. So if you've ever filled out your life insurance beneficiary designation, you know you can have it pay to your 3 kids, or your 401k or your IRA, it can pay to your 3 kids. Your bank account, your investment account, all can pay on death to whomever you want, for example, your 3 kids. So there are very good, effective ways to make it very simple. On your death, everything is just going to go basically automatically. They'll just need to bring the death certificate and show the death certificate at the bank or, you know, your investments, wherever they're held. And then what will happen is, oh, the account owner is deceased. They said they want everything to pay on death to these 3 children, for example. That's all there is to it. There is no need for a probate. It's a very good, simple estate plan, but it has to be done in advance, and the person needs to understand how it's supposed to work. And also, I just have to point out that even though we are avoiding probate, we will always do a will that confirms exactly what the dispositive plan is. That way, if you have a will backing things up, if anything was not going to go automatically because somebody forgot to do something, then it will go through the will. It might go through probate. It might not go through probate. We have something called the small estate affidavit. If the asset's under 100,000, then all you need is an affidavit to claim that asset. So that's one way you would avoid probate, because there's no benefit. There's no need for it.
But I have a question, Lynn. If you're filing a small estate affidavit, or you've already you've already put on the deed, transfer on death deed, how you want these things to go, and let's say the cars, you've got what people on the title also with your name that they would.
You're not going to put them on title. The car is something. One reason that you need a will to back up the transfer on death, because there is no transfer on death designation on the title for the car.
Oh, you can't have a second signatory on the car?
You could put somebody on it, but cars are huge liability. You don't want to put anybody else, or if you wanted to give me your car and you put my name on the title and you get in a car accident, guess who's going to be sued? Not just you, but me, because my name's on the title. So you typically will not want to put, and you wouldn't accept anybody putting your name on the title because of the liability concerns.
Okay. So like so I see the need for designating outside of probate how you want things to go. But doesn't a probate action have to be opened anyway in order does the court have to say, okay, I see that the house transfers on death to these people and that's fine with me and whatever. Do you have to open a probate action? Just not go through the whole probate process, but do you have to open a probate action?
No, under that example, there's no probate action entered. What you might be thinking of is that whoever is in possession of the original will is supposed to file it in the county where the person resided. And at least as of now, that's a $20 recording fee, but that is not opening up a probate action. That is just giving notice to the world that there's a will and it says this. That way, if somebody wanted to do some research and say, hey, am I supposed to inherit? And they see the will says, I disinherit you, so-and-so, then they don't have any rights to inherit. But there is a recording needed, but not a probate.
Okay. So it's best to have a will, even if you are setting it up to avoid probate, it's still best to go to an estate planning attorney and create a will. And then that will gets filed with the court once you pass. And that's the end of it, right?
Right.
All right.
Right.
You're setting it up not to go through probate. Okay.
Right.
So when would be a time when you would want to go through probate? What would the circumstances be for that?
There's a lot of circumstances where probate might make sense. So before I get to that though, I want to answer a lot of people, they've heard avoid probate. And they've heard revocable living trust. That's the way to go. So I want to talk about that before I talk about the benefits of probate. So with revocable living trust, the whole intent with that is to avoid probate. So if you have a revocable living trust, you have to transfer the deed from your name to your name as the trustee of your trust. And then you have to put your bank accounts in that revocable living trust. And as life changes and as things change, you have to remember to put the asset that you can and title it in the name of the revocable living trust. And if all of that is done correctly, when you pass away, this is your trust, you were the beneficiary, you created it. When you pass away, if you want it to go, for example, to your 3 kids, one of them will step up as the successor trustee, and they'll sell the house and they'll take the bank accounts and they'll divide things up. So a revocable living trust can be a very good planning tool to avoid having a probate. But I have to say, if you have a revocable living trust, if a lawyer's prepared it for you, or even if you just did it online yourself, you know that there also must be a will. And the reason there also must be a will is that so commonly people don't administer their trust correctly. They don't fund it correctly. They forget about an asset. And the will captures through a probate what should have gone via the revocable living trust, but it didn't because the person didn't keep up on what was supposed to be in the trust, and they forgot about an asset. And that asset's either going to pass through probate, maybe a small estate affidavit, but there are a lot of reasons, a lot of times the revocable living trusts simply don't work as they're intended. And I think one of the main reasons for that is people don't understand revocable living trusts. I mean, you're the trustor, the one who creates it, you're the trustee, you're the beneficiary, you're all things to this trust. You don't need to file a tax return. So it's easy to forget about, now, how is this supposed to work? And that happens. And so as a result, there's a trust administration and possibly a probate too.
Yikes. So it seems like, I'm sure there's reasons and I know that there are reasons and benefits to have a revocable living trust, but it almost seems like you're making more work for yourself and your estates You could very easily be making more work for yourself in your estate if you forget about it and don't do things correctly, right?
Well, you're 100% right. You are making more work for yourself. There's much more upfront work with a revocable living trust because you have to fund it. You have to continue throughout your lifetime to make sure your revocable living trust is being administered correctly. And the reason for all this upfront work and cost is to avoid probate. So there is much more work involved at the start with a revocable living trust. And the costs of a revocable living trust and ongoing maintenance. Oh, what if you want to change it? You've got to change the terms of the trust. You have to do a certificate. There's all sorts of work that goes with a revocable living trust. Having said that, don't get me wrong. I'm not saying it's a bad estate planning tool. It just is something that you need to understand. And just like anything, if you don't understand how it's supposed to work, well, it's not going to work correctly, most likely, if you have to be involved with making it work.
Right. I know that I advise my Leaving Lightly clients to look at their material, their end-of-life material that they have so meticulously created once a year, at least, to make sure that everything's correct and to update it, because so many changes happen during the course of the year. Would you advise the same thing with your estate planning clients, to revisit their estate plan once a year? Is that too often, too not often? What would you advise?
I like your suggestion of once a year. I don't know if people actually do it. In estate planning, we typically say every 5 years, or when there's been a change of circumstances, birth, death, remarriage, divorce, all of those things, change in health, anything that is different. When you do your estate plan, you do it according to what life looks like when you sign those documents. Well, life changes over the course of time. We say review it every 5 years, but hey, if somebody reviewed it every year, you know that they're going to be on top of it, especially if they follow up with for example, in our case, if we drafted the documents, follow up with us. I'm thinking, tell me, how does it work with Leaving Lightly? Do you have given them instructions so that they know what to do, or how does that work?
I give them the materials, I mention to them that, and it's true that all the stuff that you write down, like you say, every plan that you make is true in this moment that you make it. And so I advise once a year, particularly at like the 1st of January, starting a new year fresh is a really good time to just sit down with your Leaving Lightly materials and take a look at it and go, oh yeah, no, I changed bank accounts this year. And oh yeah, I'm estranged from this person. So I better, work that out. So I just give them the verbal suggestion to update it. And my friends kind of think I'm, a little bit bossy, but when my friends have a change, a major life change, I say, and don't forget to update your Leaving Lightly notebook, because it's true that when changes occur, if you don't record these things, then the material that your heirs are going to have to they'll get, and it's outdated and it's moot. So, whatever it is you're doing to create your estate plan, if you don't keep it updated, you're not helping your the executor, the person who's going to manage your affairs once you've passed.
Jan, I want to pause for just a moment, and I do want you to share with the group about Leaving Lightly. But one of the things that you said, being bossy, I was thinking about that, thinking about why do we care so much about helping people with their estate plan? And when I was thinking about that this morning, it's because it gives them control over their life while they're living. And it makes sure that your loved ones won't have just a mess to clean up when you're gone. So, it's the way that I, as an estate planning lawyer and as an elder law attorney, can, in my way, can make people's lives better. And I'm guessing that you share a similar passion with what you do.
It's so funny you mentioned that, Lynn, because I was thinking about that this morning. As a matter of fact, when I was getting ready, I was thinking about that this morning, and I was thinking about what the honest truth is. If somebody, and I didn't expect you to ask this question, so for the listening audience, it comes out of the blue. So I thought, what if somebody asked me why do I care? And that does come up sometimes. Why do you care if I get my affairs in order? Why are you so insistent that I do this? And the truth is, actually, it sounds And the reason I don't tell people, because the truth is actually sounds bogus, but it's the gospel truth, actually. As Lynn knows, I'm an interfaith minister, and my primary expression of spirituality is compassion. And so when I say that I genuinely care about people that I've never met, people that I don't know, about their lives being peaceful and happy, I mean it. I genuinely mean it. So if I'm speaking to a group of people that I don't know, it doesn't matter that I don't know your circumstances. It doesn't matter to me that I don't know you. I still want you to have the most peaceful, happy, successful, joyful life you can possibly have. And I know ways that can screw up your life and hurt you very badly. And I know how to avoid that. So for me to teach you how to avoid that is of primary importance to me. So that's why I do it. That's why I'm bossy. That's why I do Leading Lightly, because I know things that will help you, and I know ways to avoid things that will hurt you. So that's why I do it.
That's beautiful.
Yeah.
Jan, before we talk about more about Leading Lightly, I don't want to forget to tell everybody who's listening why probate can be the best thing in the world for them.
And Lynn, before we talk about why probate can be the best thing in the world for them, I have a question. Can we address a question now?
Of course.
Before we wander too far off the topic of the question, Barbara wants to know, is there a transfer on death deed form?
Well, you probably can find one online, yes. The transfer on death deed form needs to be filled out before somebody has passed away and recorded. So that would be something that if, we all do our Google research, and sometimes it is on point and sometimes it leads us astray. But a transfer on death deed is not that difficult a form. You can probably find it online. You just type in Washington transfer on death deed form. It's provided by a statute. There has to be a real estate excise tax affidavit filled out correctly as well. If you try to do this and go down to the recorder's office yourself, they're not supposed to give you legal advice, so you might run into some troubles there. But yes, there are forms likely. You can find forms for everything online. Revocable living trust, wills, powers of attorney, all of these things can be found online. What I would say is that what really is important is understanding, well, how does this fit with my situation, with my particular estate plan?
And can't you also get it from either the bank that holds your mortgage or real estate companies? Don't they also have the forms?
I don't know if they do. A title company might.
Okay.
Keep in mind that people who are not lawyers are not supposed to provide legal advice. That doesn't keep people from doing so. So, a title company probably would be the place that I would look more than a real estate, company.
Yeah.
But I would, there's also legal services, free legal services. WashingtonLawHelp.org is one of the best websites. So there's all sorts of legal resources available. I just want to make sure that folks realize that through a form, they're not getting counseling. So they're somewhat at risk for not understanding what's supposed to be done.
And for sure, anybody who's ever tried to fill out a legal form knows that it is one of the most confusing things that you're ever asked to fill out. So
let me give you one example of that I just came across.
Yeah.
Somebody did an online will, and this person had 3 children, but one of them died. And the person said, I have 2 living children, and didn't say anything about the deceased child. Under the laws, that means they forgot about their deceased child. And under the laws of intestacy, their deceased child gets 1/3, even though clearly the person only wanted the 2 surviving children to inherit. But because they didn't understand, the law says you must name all your children, and deceased or alive. You have to name them. And if you don't, the law assumes you forgot about them. So that's one of those situations where, problems can really arise just because somebody said, I could just do the will myself. Well, it's not what you wanted, and the result will be, an inheritance by somebody you didn't want to inherit.
Well, my question is, in that situation is, since deceased people can't do anything about it, how does that work to practicality?
So remember, the person who did the will was the parent. The parent is alive. The child predeceased the parent, and the parent doing their own online form didn't include the name of the deceased child. So when the parent dies, then the 1/3 of the estate goes to the deceased children's issue or descendants. So let's say he had 2 kids, they each divide the 1/3 into halves. So each of those kids gets 1/6 of the estate in place of their parent.
I got it. Sure. Okay. Yeah. Scary thing. So Lynn, tell me, why is probate the best thing that could possibly happen to you? This is an interesting question. I really want to know.
Right. One of the reasons is that what if you have a taxable estate? What's a taxable estate? 2.193 million in Washington. Right now, 11.7 million federally. Who knows what the level will change. But let's say that you and your spouse have a $4 million estate, and you just have what we call an I love you will. It means everything goes out right to your spouse. You failed to take advantage of a tax planning shelter trust. If a lawyer is doing a probate, they would put the deceased spouse's $2 million, their half, into this credit shelter trust. And then when the surviving spouse dies, the surviving spouse does not get taxed on what was the deceased spouse's $2 million. So there'll be no Washington estate tax, all because the right kind of trust was put in your will. Now, mind you, you can do this through revocable living trust, but I do want to caution people. One of the reasons people have revocable living trusts is they really don't want to pay that hourly fee to their lawyer. And they don't want to go back and say, okay, now what am I supposed to do now that my spouse has died? They think, I understand it, I can do it myself. And as a result, it's not done correctly. This credit shelter trust is not funded. And as a result, they didn't put the $2 million into that trust because they did it themselves. The tax on that could be hundreds of thousands of dollars, all because they didn't want to pay the lawyer's hourly fee, which I get, but you've got to look at what the consequences are of shying away from paying for professional guidance. So I just wanted to point out the tax. Let me tell you why, in what situation, probate is so important. Let's take this same couple. Let's say they have $4 million. They have an estate that is at $4 million. And one of the spouses has an Alzheimer's diagnosis. And if you know anything about Alzheimer's, you know that that period of care can go on for 10, 15, 20 years. It can go on for a very long time. So in my example, let's have the wife with Alzheimer's. The husband has no Alzheimer's. He's healthy, but then he dies either of a cardiac arrest or a car accident or whatever. He is deceased now. Where's his $2 million going to go? What we recommend and we set up frequently for our clients' estate planning is that $2 million of the deceased husband now will go through probate process. There has to be a probate. Will fund a supplemental needs trust for the surviving spouse, for the wife with Alzheimer's. Whenever she is otherwise at a point where, Medicaid will pay for her care, all that money in that trust, that $2 million won't count as hers. What that means is there will always be that nest egg for her and for their descendants after she's gone. So $2 million can be kept in a trust under my example. Medicaid will pay for her care. Now, she first has to spend down or otherwise get herself within resource limits. So, she can only have $2,000 in a house, but she doesn't have to spend down more than her $2 million. She only needs to spend that down until the Medicaid level, which for her as a single person is $2,000. yet she can still have 2 million in a trust and the state will pay for her care. So that is probably the very best example of why probate can benefit you, in that you can protect, at least half, if not 100% of the estate, the assets of a couple against long-term care costs, any creditors, taxes, etc. There's just a really good planning tool called a testamentary supplemental needs trust, and you can protect money for your spouse. And it's the only way you can do it under the estate planning rules in Washington.
Wow. It's just so complicated, and I know this ground, I know the layout of this land, and it's still complicated. I still learn new things, and I'm sorry, Lynn, every time we have a discussion, my eyeballs start spinning. I know you can't see them, but but it's complicated. And I think that that's one of the main reasons why anybody would want to go to an estate planning attorney, because it is so complicated, and the ins and outs and what ifs, so you know how to get around things. The lay of this land. I wouldn't begin to know the lay of this land, and I know more than the average bear. So I was thinking about, as you were talking about, how so many people self-medicate. They'll go to the doctor, they will get meds, and then they decide that they don't want to keep going to the doctor. They don't want to keep the med, do what they're supposed to do. And so they do it themselves, right? It's like, oh, I can do it. I can adjust myself. And so legal stuff is like, oh, I can fill out an online form. I can do this stuff myself. And the fact is that in most cases, I'm going to guess, Lynn, that you suffer if you try and do it yourself, because you don't know. I don't know what I don't know. And so my friend says that a lot. You don't know what you don't know, Jan. So is that true, Lynn?
Well, I would, if we were to put in the chat here, if I were to say, hey, if you're listening here, if you've heard about the supplemental needs trust and understand how they work as I explain it, put a yes in the chat. If you've done estate planning work with us, you'll probably say yes. But if you haven't, you're going to go, that's crazy. How does that work? You mean through a probate, through the right kind of will, I can protect 50% to 100% of all of our assets, and then the state will pay for care? Yes. That's, for me personally, between my mom and dad, we had 14 years of long-term care. So my heart really is with the people who are facing a lot of spend down, a lot of costs, the angst, everything that goes with long-term care. And that's one of my missions, is to share this information, because like you say, how would anybody know? You are not expected to know. That's why we want to get this information out, that, okay, you need to do an estate plan if you want to protect this money. All right. Well, what's the estate plan going to cost? Well, it's going to cost thousands of dollars. There's no doubt about that. What's the probate going to cost? Let's say that this probate had more complications to it. Let's say it cost $10,000. Okay. So now you've invested, somewhere under 20,000, 15,000 or whatever for, this plan and having the probate. What was the result? The result was you saved $2 million. And I'm just throwing out numbers. They're not necessarily exactly what things cost, but I just want to give some context that to protect money, you do need to spend money, because this is not something that anybody can do online or themselves. But if you look at the benefit, I do have to share, there was one gentleman, and after we signed his estate planning, you could just see him. He was always the breadwinner. He always cared and made sure his wife was taken care of, but he was dying. And through this estate plan, we were able to protect 100% of this couple's estate. And he was so peaceful. And he died not long after that, but he died knowing it was like this one thing. He wanted to make sure his wife was taken care of, and she was. I mean, that's rewarding.
Yeah, for sure. And I think that the main point there that we talked about earlier is don't wait until the very end, because it was a good ending to the story, in that he stayed alive long enough to make this estate plan and to get his wife taken care of. And then he had the peace, and then he died. But if he had died ahead of making that estate plan, can you imagine what kind of anxiety that he would have, and what kind of life his wife would have had as a result of that?
Exactly.
Don't wait.
Yeah.
So Lynn, let me ask you about choosing an attorney. Because attorneys, of course, are specialists in their field. You've gone to school for a long, long time. You personally have spent more than 30 years or something, although she was just a baby when she graduated law school. I want to make that quite clear.
I was only 25 and I've been in practice for 36 years. So do the math.
Do the math. No. Yeah, so anyway, but so, how do you know? There's a lot of attorneys out there. Do you pick a number out of the phone book, which doesn't even exist anymore, but how do you know?
That shows your age, Jan, if you're referring to the phone book, right?
I can't.
But actually, people do refer to the phone book. So, what I recommend is, especially if you do Google research, put in, estate planning and elder law attorney, wherever you are located. Go to their website. They'll have a website. If they don't have a website, you got to say, why don't they have a website? And then find out what they do. At ELG Estate Planning, what we do is exactly what we've talked about: estate planning, probate, and Medicaid asset preservation strategies. Really, that is our specialized focused area, because that's what we do. And then look at the depth of the team. Is there more than one lawyer? So when you're only dealing with one lawyer and maybe a paralegal or an assistant, what happens is something happens to them. Nobody's there to carry out your estate plan. I tell clients that, yes, we will be able to probate your estate. I hope it's not me doing it, that I am, no longer, at the helm here, and it's going to be one of my other attorneys. So you really want to look for depth of staff. And then, of course, see what people say. Do they like the work that's being done? Do they feel comfortable? I recommend that you do not go to what I call a generalist, somebody who does everything. And think of it this way. If you were going to go have brain surgery, you're not going to your general practitioner, you're going to your neurosurgeon. Now, what we do isn't brain surgery, thank God, because that is not our area of practice. But the point still holds true, is that go to somebody who has years of experience, has a depth of a team that you feel comfortable with. And you know what? If you are looking for the person who does it for the cheapest, I got to tell you, you're going to find the wrong person, because I know lots of attorneys will say, I can do your will for $500. Not a problem. Right. So what did you get? You didn't get an estate plan. You got something that you might as well just download it off of the internet yourself. Maybe that lawyer told you got to name that deceased child, maybe not. So, be careful, be smart. This is your life. This is your plan. This is your future. Don't leave it to somebody, who says, I can do that for you cheap.
Oh yeah, I know someone, a friend of mine, she's, when we were talking about a will, she said, yeah, I had my real estate agent or my real estate attorney do my will.
Mm-hmm.
Okay. I just left it. Okay.
But see, they wouldn't understand anything about what we've been talking about. They wouldn't understand about how to protect assets, how to use tax trusts, how to avoid probate if probate's not helpful. You just can't in this world. Things are too complicated to know everything. You know what you know, that is what you focus on. And you cannot do good work if what your practice area is not estate planning and elder law. I have to tell you, the elder law piece and component that we do Medicaid applications very much impacts what kind of estate planning documents we draft, because we know what Medicaid requires. If they're not doing Medicaid applications, they don't know what needs to be in the estate plan. So traditional estate planning lawyers or even elder law attorneys, they say, I don't do Medicaid. I would be concerned that you're not getting, a plan that gives you all of your options.
Mm. And you had mentioned to me one time, Lynn, that I could, anyone can interview an attorney. So how does one go about interviewing an attorney?
Well, you just, first of all, you go to their website. You say, hey, do I like the feel of this? Are they giving me resources? Do I like the feedback? Does this feel right? And then you can reach out to the law firm and set up an initial consultation. It may or may not be with a lawyer. We have found oftentimes that Lawyers tend to talk in legalese, and I'm a problem solver. I want to get right into solving the problem. So I'm going to be talking at a level that might be, whoa, a little bit too much for somebody who's just coming in and interviewing. So we have a client needs consultant who will often meet. That's a non-attorney, but this person knows what we're talking about, what we do here. And then that way, both sides, us and the potential client, can say, this seems like it'll be a fit. And if so, then next step is to have that legal strategy meeting with a lawyer.
And is there a cost involved in this?
It depends on the situation. Oftentimes we may have complimentary if it seems like a good fit. Sometimes we do charge, and the charge could be, $100 to $375 to $750. What's really important to us is that we reach out and we serve clients. So we try not to make that consultation fee a barrier. And that's why I say sometimes we will waive the consultation fee if we feel, just from the initial interviewing, before the potential client comes in, that it seems like that this will be a good fit.
Okay, very good. And Lynn, we've got a few minutes left. Do we want to talk a little bit about the role of the personal representative?
Jan, I want to throw it back over to you, because I know you have and probably are serving right now as a personal representative. And if you could not give everybody all the details about how frustrating it could be, but how can people, through estate planning and through the planning that you do for Leaving Lightly, how does that make the personal representative's job easier?
Well, I'll tell you, I never wanted to be a personal representative, but I have had an aunt and uncle that I love very much, and they really didn't have anyone in their lives who could handle this job and responsibility. And that's the first thing I want to bring out, Lynn, is that not everybody can do this job.
It's a job. The person has to be business oriented, get stuff done. It's not an honor. It is a job, and it takes a lot of work, and you should be guided by an attorney who you're working with well.
Absolutely. It is. Yes, it definitely is a partnership with the attorneys. And that, if you don't work well, it becomes even a more significant problem. So because I have spent a lot of time in law, I knew the lay of the land, and I finally agreed to do it. And the first thing I want to say about a personal representative is that you don't have time. If you're being the executor, which is another word for personal representative, if you're being the executor of someone's will, you don't have time to grieve their loss. You really don't, because your job kicks in when they pass. And in my case, my aunt passed, and then my uncle passed 7 months later. And I didn't, at the time he passed, I got word from my cousins, his heirs, that he had passed. And and I think, Lynn, that this is not an isolated, and I don't think this is an unusual thing. I got word that immediately upon his passing, the family was going through the effects of the house and taking what they wanted out of the house. Now, I had gone with my aunt and uncle to an estate planning attorney. We had created, while they were alive, obviously, we created an estate plan for them. I was the executor listed in there, so I had a legal designation. I knew that all the possessions of the house were to be sold, and that the proceeds distributed to the heirs. So that means that people couldn't just walk into the house and take what they want and walk out with it, So I lived 500 miles from my uncle. So I got word of this happening, and I ended up, how am I going to stop this process? And I'm responsible here because it's my job to oversee what's going on. So it's like, oh my Lord. So what I had to do was get on speakerphone. I made the bossy. I'm bossy. There's a bossy for a reason. Sit down, stop, cease and desist from taking things out of the house. Sit down, let me talk to you. So I talked to them on.
I think, and every situation is different. And I think it's good for you to share. I do want to mention one thing. If a single person dies, then yes, the job right away is to make sure that the pets are taken care of, that the house is secured, that people aren't going to be going in and stealing from the house. With a married couple, what we typically tell people, once they've made sure that there's no pets starving, is take a couple weeks at least to grieve your loss. The business aspect of an estate can wait. So just like everything we're talking about, Jan, it's the circumstances. Do you need to jump in right away because there are critical things that need to be taken care of, the house, the pets? Or is it your spouse has died and, you are just trying to figure out what to do, where to put your foot in front of the other? Take time. Don't feel like you have to go meet with a lawyer right away. So I wanted to share that. And because unless you've been through a probate, unless you've served as a personal representative, you don't know these things. And even if you had, your situation, your feeling about it is going to be colored by what your experience is. And, the experience is going to, in large part, be dependent upon the family dynamics, geography, and your partnership or your work with the estate planning lawyer.
Absolutely. Yeah.
I know we're coming close to the end of our time, Jan, so I don't want to, I know we could probably chat forever, but I don't want to do that to the audience here. Can you just tell us a little bit more about leaving lightly, a little bit more specific so that usually people know what an estate planning lawyer does. So, but yeah. What is leaving lightly? Can you just give us a little bit more information about that?
Well, leaving lightly really is the non-legal aspects of, and I use the term getting your affairs in order. Really, it's about writing down the passwords to your computer because most of us live our lives on our computers. But if your executor, your heirs are not able to access your iPhone and get into your iPhone or your laptop where you keep your contact information, your bank account numbers, your bills, all that. If they can't access that, they've got nothing to work with and go on. So it is designating who's going to get your pets. A lot of pets end up in shelters because the owners died, the single owners died, and there was no one to take the pets.
How many pets did your aunt and uncle have?
My aunt and uncle had 6 senior dogs. And they didn't know what to do with them. So when my uncle passed, and that was one of the urgencies, that's why I did have to jump in because, these dogs have to be fed. So that, and finding a home for 6 senior dogs, that was fun. Yeah. So those kind of things, making sure that like your original marriage certificate, you need to have that. And so your original divorce papers, you may need to have that. So, and your mother's maiden name, you need that for the death certificate. So having these things recorded is a primary importance for the person you left behind because they're going to have to administer your estate and put a close to your life, your bank accounts, your bank account numbers, all like that. So it's giving them the tools they need really to carry on your life as you, so that they can bring your life to a close when you're no longer here. So that's the premise really of leaving lightly. And
so I take it it's like a workbook that they put all this important information in.
Right, exactly. I've got a paperback book that tells you all kinds of things in the area of administrative things you're going to need to know, the health and legal documents that you're going to need to know, which overlaps with what Lynn does, of course. What to do with your physical body when you no longer need it. I've identified 10 things you can do with your body when you no longer need it, and creating a digital profile, a digital presence, so that once you pass, your voice, your mannerisms, your family history is recorded for the people that you love and have left behind and future generations of your family. So that is leaving lightly altogether. And yes, we have a comprehensive paperback book that describes everything, a workbook where you actually write down all this information, and plastic sleeves that you can keep your original documents in, and a digital format of that also is available. So that's what leaving lightly does.
Well, that fits in so well with what we do. When we do our estate planning notebook, not to the detail that you go through, but, get your important papers together and in the notebook and put in one place to make it easier for, whomever might have to carry on after you're either disabled or gone. So I think it's a fantastic idea.
Yeah. So the idea, of course, the premise and what I was saying in the beginning about being compassionate for the ones you leave behind, just getting your affairs in order through estate planning and getting that handled, and through the non-legal aspects that need to occur. Also, you are being loving, kind, and compassionate to the people who mean the most to you at a time when it means the most, really. And for me, in my expression of compassion, as a way of life. That's one of the most important things that any of us can do, honestly. Don't you think, Lynn?
It's a gift that you leave for your loved ones, and you put it so well. Yes.
Mm-hmm.
So for those that have, been with us today, thank you so much. I know that sometimes probate and talking about death and, estate planning isn't the most fun topic, but it's really important. One of the things that we've done at ELG Estate Planning is we put together a probate road map, and we will be sending that to you via email as a way of saying thank you so much for being here and listening. So we're going to send that to you via email. Jan, what is it? Tell us a little bit more about what you have that you can provide to the listeners.
Right. And so we have a little ebook, really basically a short little document called 9 Ways You Can Save Hundreds, Thousands, or Hundreds of Thousands of Dollars at the end of life. And so really I outline 9 different ways where you can not leak money, and you have the potential to leak money, and ways that your heirs can save that money instead and let that money go to the people that you want to have your money, as opposed to going to the state or going to other things, or doing emotional buying, which is a really big one. So anyway, that's part of the offering as well. You get both Lynn and I benefits from both of our different disciplines.
So our website is elgwa.com, and I think we'll put that in the chat. Our phone number is 509-468-0551. We'll put that in the chat. Jan, how do people get in touch with you?
Well, you can go to livinglightly.com, and that's my website. So you can find me there and find the things I mentioned about the book and the notebook and all like that. That's listed there on the website. But I know that Colleen's going to send out, when she sends out Lynn's probate checklist, she's also going to send out my Living Lightly 9 Ways You Can Save This Money. So they both come together, right, Lynn? They come in one package.
There you go.
For the price of one. It's all free.
We want to make it simpler, don't we?
We do. Yeah.
Thank you, everybody. Jan, it's been a pleasure talking with you. Just wonderful. And thank you, everybody, for joining us. We look forward to seeing you next time.
Very good. Take care.